Welcome. Good evening. My name is Mika Thompson, and I will be your host today for the Cook County Bar Association's Live on Can TV show. To my right and your left is the distinguished attorney Lewis Powell III, and he will be discussing real estate. We're going to get a general overview of some very important aspects of real estate law. I want to inform you that the Cook County Bar is the oldest association of African American judges and lawyers in the United States. And we take this time every evening on Wednesday at 6 p.m. to bring you information of legal import and to discuss issues that are affecting the larger Chicagoland community. So, Lewis Powell, would you take a moment now to introduce yourself to our viewers today?
Well, Mecca, first of all, I don't know about the distinguished part, but that was very kind of you.
I know, and you're very distinguished.
I like to say I'm fundamentally sound. How about that?
Very good.
But in any event, it's good to be here, and we're going to try to keep it rolling. Going to try to give you an overview of the role of the real estate attorney, touching a couple of topics, and really hope, Mika, that, that our viewers in TV land will give us a call and ask some questions so we can
right.
engage them.
Right. And I'd like you to know a little bit about Attorney Powell's background. So let give us a little introduction.
Reader's Digest version. I had the honor of working for Mayor Harold Washington, as well as my fraternity brother Eugene Sawyer, back in the day for the city of Chicago. Prior to that, worked for the Village of Robbins in the Economic Development Department. I actually spent a year with Chicago Housing Authority in the legal department. I've been on my own in private practice for 93 going forward. Have taught at the John Marshall Law School for actually approximately 22 years in the area of fair housing. We love to do real estate. Real estate is my passion. I'm a small-time real estate developer, and so forth and so on.
So we are very fortunate today to have such a distinguished attorney with a very extensive background in real estate to answer any of your questions. So feel free to contact us at the number below. This is 312-738-1060, and give us any question that you have. We're talking about real estate today. I am your host, Mika Thompson, and this is Attorney Lewis Powell III, and we are here on behalf of the Cook County Bar Association. So to begin, what can you give us just a brief description or definition as to the role of a real estate broker?
Sure. The real estate broker is critical. The real estate broker is actually an individual. It shows the properties. Now, ladies and gentlemen, the realtor does not have the obligation to show you each and everything they have in the inventory. And the inventory will be the MLS. The MLS gives the broker a multiple listings in terms of properties that are available. Because a broker is just like everybody else. Their time is worth money.
Right.
And if you can't afford a particular house, they're not going to waste their time showing it to you.
Okay.
Most good realtors are trained to qualify their clients quickly. Okay. And they can try to qualify them based on information that they give to the realtors. A lot of realtors have connections with mortgage brokers, mortgage lenders, and they will immediately, as soon as practically possible, connect them with a mortgage broker or a lender. Why? To try to determine what the feasibility is in terms of getting a mortgage, and also just as important, what is their price range. Because again, you don't have time to be Sunday shopping. You want, as a broker, you want to be showing people houses, properties, so forth and so on, that's within their time frame. Well, excuse me, strike that. Within their price range.
So when you say qualified, that's a little different than what the mortgage people do with their pre-qualification, pre-approval process. You're looking at whether, one, how much can this person afford based on their ability to be approved by a mortgage company. Is that what the...
Exactly. Okay. Make it a different types of qualifications.
Okay.
There can be what's called a pre-qualification. Is based upon the information that you as the potential client give to the lender.
Okay.
There's a qualification based upon the lender independently verifying information that you're giving. Okay. Now, what we say, the proof is in the pudding when you as the potential client goes through the underwriting process. Because even though you may be pre-qualified based on information that you have given to the lender, you may be pre-qualified based upon the lender verifying what your credit is, so forth and so on. The underwriting process is really where it determines thumbs up, as we say in the business, a thumbs down, whether you get approved by the lender in terms of a specific interest rate, a specific loan amount.
Okay.
Those are the key. A loan commitment is state what the interest rate is, how much you can borrow, so forth and so on. The real estate broker, again, is the person that will show you the properties.
Right.
Now, in the fair housing aspect, the realtor has to be very careful. He has to be fair in showing what he has. Now, he's not obligated, or she's not obligated to show everything, but you cannot make the distinction for fair housing purposes in terms of, for example, showing the African American the west side of town,
Right.
showing the Hispanic brother the north side of town, so forth and so on, and the Caucasian person the east side of town.
Right.
Okay, that's called steering. When you
Okay.
yourself are taking upon yourself to determine where you think a particular person needs to be because of their race or ethnicity.
Okay.
Now, with the real estate broker,
Okay, it looks like we have a caller. Caller?
Yes.
Okay, you're on the air. What is your question?
My question is, I live in the city of Chicago.
Okay.
And I've been getting the Chicago police come into a private lot and give me tickets on my car.
Okay. And so the car, you're saying the car is parked on your, do you own the land?
In the complex. No,
Okay.
it's Laramar Properties. Laramar Properties is on the building.
I didn't understand your answer. Do you own the land that the vehicle is parked on?
No.
No. Do you have a lease that says that you can park in that area?
Yes.
Oh, okay. Okay. So do you want to answer that?
sure,
Okay.
that's off topic,
Right.
but we get off topic all the time.
That's
I'm going to
fine.
answer it to the extent we can.
Okay.
Okay, basically, the city of Chicago can ticket you almost any time they want. Okay, the fact of the matter is the city's coffers are bare. They're ticketing people in terms of high grass. They're ticketing people in terms of having garbage that's overrunning the garbage cans.
Okay.
So forth and so on. They'll even ticket you if you have a vacant lot and don't have a fence around it.
Right.
So the fact of the matter is the city of Chicago, if they can visually see something that's a violation on private land, they chances are they'll try to ticket it.
Okay.
And there's a question whether they can go on private land as opposed to open lot. But the bottom line is that the city of Chicago can ticket anything to a certain extent they can that's in plain view.
So is he able to challenge this?
He can challenge it, but the fact of the matter is time is money. Most people, because I'm in building court a lot for my clients. Okay? Because you can be ticketed by the street of sanitation in terms
Right.
of high grass,
That's true.
not having a fence around your property,
That's
so
true.
forth and so on, garbage coming out of the garbage can, which a lot of times it's not the landlord's fault because people will dump on your property and you
Right.
get charged on it. But the fact of the matter is that you can challenge it. Quite honest with you, very rarely will you win.
Right.
The majority of the time when you get ticketed for streets and sands, for building code violations, the majority of the time you're settling for a reasonable fine and getting into compliance.
Right, right. So you may be able to go into ask for a hearing and present your lease and show that you have permission to park in the lot if the violation was that this was parked, the vehicle was parking, you didn't have permission to park there. It really depends on the violation that appears on the face of the ticket. So if you need more detailed answers to that question, caller, or callers, any other more detailed answers to any questions that you have, please feel free to contact the Cook County Bar at their Lawyer Referral Service. The number is 312-630-1157, extension 1, and you can also go to www.cookcountybar.org and select Programs and Services and scroll down as I'm doing here to Lawyer Referral. There are a list of private attorneys that and their phone numbers and the area in which they practice that appear on the website, and you can contact them and have a confidential conversation and ask the question that you need answered and get the more detailed explanation for your particular legal issue. Now, continuing our conversation, we were talking about the qualifications, and you were explaining we had gone into the role of the broker to the extent that they are not obligated to show their clients everything that is available, but in showing their different housing, they must be fair. They cannot discriminate and only show people of certain races, certain areas. I do want to just step back for a moment with regarding to the qualifications aspect, and because you did talk about the lenders, but is there a process that is involved in qualifying someone that comes with cash when they're ready to purchase a particular
Cash is king.
Okay.
Okay, with cash, it doesn't matter what type of credit you got.
Right.
As a matter of fact, most sellers will take a lower cash contract than a contract that is higher with a mortgage. Why?
Okay.
Because cash is guaranteed. Okay, cash is king. In this day and age in real estate, if you're liquid, you can do a lot of damage.
Okay.
So, the moral of that tune is if you have cash, or just as good if you have a line of credit that you can really access, you can do a lot of things quickly. Because again, cash is queen. No qualifications. Because with cash, you're probably closing much quicker than with a mortgage.
And so then it's more important for the buyer to really know what they're looking for, what they can afford, and after that cash is expended, what type of things they don't want to have to deal with. Isn't that right?
Absolutely.
Okay, to better inform their broker.
Absolutely.
Okay.
Absolutely.
So moving right along now, the role of the lender, because you kind of intimated that what they, as far as the mortgage, how do you describe the role of the
Sure,
lender?
we're going to hit it in quick.
Okay.
We're getting all the information we can.
Okay.
The role of the lender, quite obviously, is to loan the money. You have to have a certain amount of credit. You have to have a certain amount of credit rating. But again, lenders can make discretion.
Okay.
Lenders have a lot of discretion. Even though you may have a low credit rating, some lenders will still work with you. Some lenders will allow you to give explanations in terms of slow credit. What we're talking about.
Okay.
If you have a history, if it's during certain time periods that you have paid slow on some bills, sometime it may be a reason. Maybe because of hospital bills.
That's true.
It may be because of debts and so forth and so on. Maybe you have some extenuating circumstances. Lenders that want to work with you will allow you to submit a letter of explanation stating why for a particular period that you have paid late. Now, with lending, and this is a little bit fair housing, lenders can get sued if they get caught not loaning on purpose on a particular area,
Okay.
which is called redlining. Or redlining is everything outside of the red line they will loan, everything inside the red line they don't loan.
Okay.
That's a fair housing concept. Okay, without being able to borrow the money, you can't get the property.
Right. That's true. That's true. Okay. So when now the buyer has obtained a realtor or a real estate broker, and they have identified their lender, and they're going through the approval process with regards, identified the lender, and they know who they want to have loan the money. Now we want to look at the contract. The house has been selected and a contract is on the table. So can you give the viewers an understanding of what's the process that takes place when it's time to review the real estate contract?
Absolutely. Reader's Digest version.
Okay.
First of all, ladies and gentlemen, do not be afraid to sign the contract without your attorney reviewing it. And we're talking about a regular real estate transaction. We're not talking about a sophisticated commercial transaction.
Right.
We're talking about a regular residential transaction. Why? Because most attorneys, including me, it is very hard for me to stop what I'm doing for one contract.
Right.
Okay? Now, over the years, the custom and practice has been to have in all contracts what is called the attorney review period. I tell my clients to get at least 5 business days if possible. Business days is longer than calendar days.
Yes.
The weekends do not count. That gives you time to review the contract. So do not be afraid. if the broker encourages you to sign off on the contract. Why? Because quite frankly, if you wait for your attorney to review it, you may lose the deal.
Right.
Because again, it's kind of hard to stop what you're doing for one contract.
So they really just need to look and see if that clause is in it. Is there something
Right.
in there saying attorney review and
Right.
having a 5-day?
But it goes more than that, man.
Oh, okay.
I tell my clients, you got to read that contract just like me.
Okay.
Okay, now again, you're not, I'm your attorney, but you need to have a fundamental understanding of what's in that contract.
Okay. So
then
viewers, take notes.
you have a
This is very important.
fundamental understanding. Just a couple of quick things. Now, there are different concepts that you need to be aware of. Okay, 1, you review the contract. 2, you make sure at least 5 to adequately review the contract. Now, what you're looking for, at certain things you're looking at, as is condition.
Right.
As is condition, transaction is closed, you cannot sue the seller for defectives. Okay, that means any undisclosed, you cannot circle back and sue the seller because something popped up after the fact. Now, when it's as-is condition, is you can do. With as-is condition, you can still have the property inspected, and if the property is in a condition that was more than what you anticipate in this present state, is not in unsatisfactory condition. It's in unsatisfactory condition. Home repair. Okay, I like to tell people there's no building. All buildings have something slightly wrong. But the key with the home inspection is that you have to be reasonable. The period of home inspection is, for example, most of them have like 5 business days for you to do the inspection. If you find this is what you feel is wrong with the property. Now, by notifying the seller, in terms of the property, what is wrong with the property, fix the repairs or correct what is wrong. Option number 2, maybe give the buyer a credit, meaning that's less money you bring to the table. Mecca, do absolutely nothing. Okay? Once the seller expresses what he's going to do, then it shifts to you to buy. Okay? Because then it's negotiating. Counter offer. Okay, what a counter offer is, you see initials. You can initial changes in price. Okay? Also, you can initial terms, different term condition. But one thing, ladies and gentlemen, be very careful with as is.
Right.
I want our audience to get that concept, as is condition, meaning that the property, once it is closed, you can't circle back.
You're taking it as it is.
As it is.
As it is. That's important. And so in that situation, if you see a contract before the attorney has had an opportunity to review it, before you've signed it, and you see as is in the contract, you really need to take a thought of your own budget and what you really can afford, what you cannot afford, and maybe communicate that to your attorney and see if that's something that you even want to pursue, right?
Absolutely. If it's as is, I highly recommend it off the initial review that you don't sign it.
Right.
That's one less thing we have to try to get you out of in terms of the modification. Moving on, Mecca. Most contracts have 2 critical provisions. One provision is that you usually have, under most contracts, X amount of days to apply for your loan. When you sell somebody a property, you don't want them twiddling their thumbs. They're supposed to be actively making application for a loan. And most contracts will have maybe like 5 to 10 days that you're supposed to have made application.
That's true.
Other critical component. Most contracts will have a date certain that you're supposed to have your financing intact. Not applying for the loan, financing intact. What we said earlier, you getting a commitment letter stating that you've been approved for X amount of money, X amount of dollars, at a certain interest rate, so forth and so on. You approve without conditions. Conditions could be that you need to turn in your income tax that you didn't file.
Right.
Okay, that happens to some people.
That's true.
All right, or you get less of explanation. But a commitment, a true commitment is no conditions. Okay, that's the second time frame. The third one is the closing date.
The closing
Okay, now the closing date means by date certain, you are supposed to be in position to close the loan. Now, ladies and gentlemen, I tell my clients, if the cutoff date for you to have your financing is June 20th, don't call Attorney Powell on June 19th and tell me you don't have your financing.
That's true.
That's critical. I tell my clients, you check in with me at least 5 to 7 days prior to the cutoff date. I need you to keep up with it too. And you advise me that you do not have your financing. Why? Most contracts provide that if you don't have your financing in place, that you can get extension,
Right.
or you can terminate the contract.
They can terminate the
Okay.
contract. So yes, you need to. Those are very good tips. Thank you. With regards to what we need to do when we're signing our first contract. So now I think we're going to shift to a different aspect of real estate. The condo. Special concerns. What kind of concerns should a buyer have that's interested in purchasing a condo?
I'm gonna try to get it done in a minute.
Okay.
Okay, what you gotta look out for is a form called 22.1, which really forces the seller to disclose with the information from the condo association what the budget is, because you certainly don't want to buy a condo that's it's an association that is broke. You certainly not want to buy a condo
That's a good
that
point.
that it is anticipated you got special assessments, okay? Because special assessments are over and above your regular assessments.
Right.
You need to look at the bylaws. Why do you need to look at the bylaws? Say you're buying a condo with the intent of maybe living in it for a while, but you want to rent it out. Some bylaws will prohibit the unit being rented out.
Okay.
So, Reader's Digest version. 22.1, form that most realtors are very good about getting and getting the association to fill it out, because it gives a complete picture in terms of the financial condition of the property. Because again, you don't want to be buying into something in terms of, special assessments are going. You don't want to be You don't want to be buying into a condo that the budget is obviously underfunded. When I say underfunded, they don't have much in reserves. If they don't have much in reserves, if something happens physically to the property, they don't have the money to cover it, which leads to special assessments.
And so, would that also disclose any type of lawsuits that may be pending against the condo association?
Possible, to the
Okay.
extent that they know.
Okay. All right. Okay. And then, is there, at some point I remember there was some laws regarding condos association being able to place back assessments of the prior owner onto the new owner. Talk to us about that.
Okay, I'm gonna hit it quick.
Okay.
That's another seminar. If you buy a foreclosed property, technically they can try to tack on 6 months of the previous assessment that were not paid.
Wow.
Okay, so you got to watch that, because they will do that.
Okay. So the last point that we wanted to touch on, Attorney Powell, is the closing.
All right.
What happens with the closing?
Very good. The attorney reviews the mortgage documents. To the extent the attorney can, he explains the terms of your mortgage. If he or she cannot understand it, the good attorney will pick up the phone and put you in contact with your lender, because that is their docs, and have them explain it. You review the title commitment. The title commitment has the history of the property, if they liens, so forth and so on. It should show up in the title commitment. Ultimately, a title commitment leads to title insurance. Title insurance is absolutely critical, because the reason you're closing at a title company, they have adequate insurance coverage. So if they miss a lien, that means they're obligated to pay off that lien, because the purpose of title insurance is to make sure that you get clear title.
Clear title.
Also, your attorney is going to review the documents prepared by the seller's attorney. What are those documents? The deed. You certainly want to make sure your name is spelled right. Certainly you want to make sure the legal description is spelled right.
Correct.
Certainly you want to make sure the tax ID number on the deed is correct. Affidavit of title. Affidavit of title is critical. It's basically saying that the seller is guaranteeing, to the best of their knowledge, they have not caused any cloud on the title.
That means they own it.
They own. That means more than that. It means they didn't run out and have something done to the property and got it liened up.
Okay.
All right. Also, you have what's called a bill of sale. A bill of sale conveys ownership of the personal property. The real estate is the building itself. Everything inside the property is personal property. Fixtures, plumbing, heating, so forth and so on. That is personal property, and the seller is obligated to give you a bill of sale conveying ownership of the personal property.
Well, I would like to thank you, Attorney Powell. We have had a wonderful discussion, and I think we've learned a lot, and myself included, as to the overall view of real estate, particularly with regards to a sales transaction, as well as with whether it's a residential property or a condo structure. So, thank you for tuning in. Thank you, callers, for your calls. Please tune in next Wednesday, where we will also have a discussion of legal import, and you can call in and ask questions to the attorneys who have the experience in that particular area of law. Again, you have a good night, and thanks, Attorney Powell, for answering our questions, and we hope that you get an opportunity again before the season is over to speak to us. We will do.